Sorry, I should have asked if y'all were ready. Sir, please tell me your name. 21 CF 8040. You're here because a warrant was issued for your arrest, charging you with aggravated stalking after injunction and aggravated stalking after a court-prohibited order. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Your bond will be $50,000 on count 1, $25,000 on count 2. You can't have any contact with the victim. Do you understand what no contact means?
Ma'am, there was a court order stating it's a family court that I have contact with her because a child is involved, and that's the only reason why I had contact with her because of that court order.
At this time, I'm ordering no contact. Do you understand that? You can't possess a weapon, firearm, or ammunition. You can't be within 1,000 feet of the victim's residence or place of employment. Do you understand? Good luck, sir. Please tell me your name.
Alan Cobb.
21 CF 8186. You're here charged with aggravated assault with a firearm, domestic violence, and aggravated assault with a firearm. There is probable cause. I'll appoint an attorney to represent you. Your bond is $15,000 on count 1, $5,000 on count 2. You're not allowed to have contact with any victim or witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. Were you living at this residence?
Yes.
You can't now. I'll order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. All right, good luck. Please tell me your name.
Francisco de la Rosa.
21 CF 8220. You're here charged with tampering with a witness and battery domestic violence. There's probable cause in this case. I'll appoint an attorney to represent you. Your bond will be $2,500 on count 1, $100 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you two living together?
No,
All right, so there's no reason for you to return to her residence.
no, not at all.
All right, I will order that you're not allowed to return to her residence for any reason. You're also not allowed to possess or consume any alcoholic beverages. At this time, I'm revoking your bond in 21 CF 961. Good luck. Please tell me your name.
Lisa Dye.
21 CF 8221. You're here charged with criminal mischief, damage greater than $1,000, battery, dating violence, and resisting an officer without violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond will be $1,000 on count 1, $100 on counts 2 and 3. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you two living together?
No, ma'am.
So you don't have any reason to return to her residence?
No, ma'am.
I will order that you're not allowed to return to her residence for any reason.
I would just have you set a higher monetary bond on the bond case, Your Honor, as a traffic violation, non-violent offense, providing false identity.
However, Counselor, this is a violent offense, and it shows a pattern that your client is having a hard time following court orders. What says the state?
Your Honor, as I don't see a history of violent offenses, I would have no objection to revoke and double.
This time I'll revoke your bond on your out-on-bond case, and I'll double those bond amounts. Good luck. So No, it's 2 counts.
I'm gonna check the bonds now.
All right, thank you. Please tell me your name.
Tori Fernandez.
21 CF 7964. You're here charged with armed burglary of an occupied dwelling, aggravated assault with a weapon, domestic violence, and criminal mischief, damage greater than $1,000. A warrant was issued for your arrest. Another judge has already found probable cause. I'll appoint an attorney to represent you. Did you wish to testify this morning?
I do not.
You do not? All right, thank you. Does the state wish to be heard on bond as to count 1?
Yes, Your Honor, as that is the PBL, I would ask for no bond.
No argument, Your Honor, pending an Arthur hearing downtown.
At this time, you'll be held without a bond on count 1. It's a first-degree felony punishable by life in prison. On count 2 and 3, I'll stay the bonds at $2,500 and $500. With special conditions, you're not allowed to have any contact with the victim even while you're in custody. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. I'll order you must surrender the firearm in question to law enforcement within 24 hours of your arrest.
Your Honor, I think
Was it a
knife.
firearm or a knife?
I think it was a knife.
All right. Were you two living together?
Yes.
You can't. I'll order you must maintain a separate residence and allow one-time return with law enforcement to gather your belongings. Good luck. Please tell me your name.
State your name. Jose Beltran Gonzalez, ma'am.
21 CF 8187. You're here charged with aggravated battery. There is probable cause. I'll appoint an attorney to represent you.
He does otherwise qualify for PTR, Your Honor.
I don't understand how.
Yeah, I want some
That doesn't seem right to me. Your bond will be $5,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon, firearm, or ammunition. Were you two living together?
No, Your Honor.
So you have no reason to return to her residence?
No, Your Honor.
I will order that you're not allowed to return to her residence for any reason. Good luck. 21 CF 8012. It's a warrant. I'll appoint your office counselor.
Waive the appearance, Your Honor.
And the victim is here, Your Honor.
All right. Thank you. Good morning. Do you wish to testify in this case?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Jessica Augusto, Agosto.
State you may inquire.
Good morning, Ms. Augusto. How do you know the defendant?
He is my boyfriend.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No.
While this case is pending, would you like to have contact with him?
Yes.
Should this happen again, something like this happen again, would you be willing to call the police?
Yes.
I have no further questions, Your Honor.
Mr. Brands?
Good morning. Are you afraid of Mr. Maldonado?
I can hear you.
I'm sorry. Good morning. Are you afraid of Mr. Maldonado?
No.
Thank you. No more questions.
All right, the bond will be $5,000. I'm ordering he's not allowed to have any contact with the victim. He must maintain a separate residence, no weapons, firearms, or ammunition. I'll allow one-time return with law enforcement to gather belongings.
No contact even with witness testimony, Your Honor?
Yes. Thank you for coming this morning, ma'am. Good luck. Please tell me your name.
My name is Gifford McDonald.
21 CF 8208. You're here charged with aggravated assault with a deadly weapon, domestic violence. And in 21 CF 4801, you're charged with battery, domestic violence, and resisting an officer without violence. I'm going to appoint an attorney to represent you in both cases. Ma'am, do you wish to testify?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Avalon Ruth McDonald, last name Donald.
State you may inquire.
Good morning, ma'am.
Good morning.
How do you know the defendant?
That's my husband for 15 years.
Has something like this happened before?
No.
Are you afraid of him?
Yesterday was the first time he ever did what he did. And I don't know why. And I wanted to drop the charges.
I understand that, but are you afraid of him?
Not really.
Not really?
No.
Okay. Should something like this happen again, would you be willing to call the police?
Yes, if it happens again, because I don't know why all of a sudden this is going on.
Okay. And while this case is going on, would you like to have contact with him?
I would like him to be removed from the house. And that's what I asked the officers to do, to just remove him, ask him to leave, because he keeps telling me he's leaving, and he's not leaving. And I don't know what happened yesterday.
Okay, thank you. I have no
Okay.
further questions, Your Honor.
Mr. Brands?
No questions, Your Honor.
All right, thank you, ma'am. Ma'am, you can stay there if you'd like. All right, Mr. Gifford,
Yes, Your Honor.
I see that he qualifies for pretrial release. Is that accurate?
Yes, Your Honor.
Does the state object?
I would at least ask that there...
Sir, look at me.
I would at least ask that there be a bond set with it, with, of course, whatever conditions the court found necessary. I don't object in and of itself, but
All right, at this time, I'm going to place you on pretrial release in both of your cases. I'll require you to post a bond, but I'll reduce the amount of the monetary bond. In the felony charge, your bond will be $1,000, and on the misdemeanor, your bond will be $250 for the battery. You're not allowed to have any contact with the victim. Do you understand what no contact means? You're not allowed to possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. All right, good luck. Thank you for coming, ma'am.
Thank you.
Good luck. I'm just straight PTR. On that one. So on the two domestics, it's a monetary bond.
and with regard to the resisting without?
Just PTR.
Okay, thank you.
Please tell me your name.
Damien O'Harrell.
In 21 CF 8211, you're here charged with aggravated battery on a pregnant person, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Ma'am, do you wish to testify?
Yes, ma'am.
All right, please raise your right hand to be sworn. And sir, you look at me. No, not you. She's being sworn. You just look at me. It's okay.
Want to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record and spell your last name.
Shantoya DeVos.
I'm sorry, what's your name again?
Shantoya DeVos
And spell your last name, please.
is D-E-V as in Victor, O-S-E.
State you may inquire.
Say it again?
No, the state's going to ask you some questions.
Okay.
Good morning, Ms. DeVos. How do you know the defendant?
He's my boyfriend
And how long have you been together?
for a year.
Has something like this happened before?
No,
Are you afraid of him?
no,
While this case is pending, would you like to have contact with him?
yes,
Should something like this happen again, would you be willing to call the police?
yes.
I have no further questions, Your Honor.
Good morning. Do you have any children with Mr. O'Hara?
Just the one I'm carrying.
Thank you. No more questions, Your Honor.
All right, at this time, your bond will be $5,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, yes.
You can't possess a weapon, firearm, or ammunition. I'll order you must comply with any plan set in place by DCF. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. Then in 18 CF 14986, you're here for a violation of probation. That has no bond. I'll appoint an attorney to represent you in that case as well. Good luck, sir. Thank you, ma'am. Good luck. Please tell me your name.
Daryl Smith.
21 CF 8217. You're here charged with battery, domestic violence by strangulation, and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. I show he's on federal probation. Is there a VOP pending? Interesting. I don't know if they'll violate your federal probation for this, sir, so you'll have to just stay in touch with your attorney. Your bond is $5,000 on count one, 100 on count two. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. All right, good luck. Please tell me your name.
Lovely Akisa.
21MM 4802, you're here charged with battery domestic violence. There's probable cause. I'll appoint an attorney to represent you. Do you wish to testify?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record and spell your last name.
First name's Oliver, last name is Aquissa, ACQUISSA.
All right, I'm going to allow the state to ask you some questions. You can put your, okay.
Good morning, sir. How do you know the defendant?
I'll say that again.
How do you know the defendant?
Oh, that's my sister.
Okay. Has something like this happened before?
Never.
If it were to happen again, would you be willing to call the police?
Oh, yeah, of course.
Are you afraid of her?
No, not at all. I actually want the case to come fully dismissed.
Okay.
I can't hear you. What did you say?
I like the case fully dismissed.
Oh, you'll have to talk to the state about that, okay?
Okay.
And would you like to have contact with her?
Yes.
I have no further questions.
No questions, Your Honor.
All right, thank you for coming and testifying. Ma'am, at this time, I'm going to place you on pretrial release with special conditions. I'm going to allow you to have contact with the victim, but it has to be peaceful. Do you understand what peaceful contact means?
Yes, Your Honor.
No yelling, no shoving, no butter knives.
Yes, Your
You
Honor.
understand? All right. You two live in the same house?
Yes.
And just to be clear, you do want her to come back to that residence?
Yes.
You have to answer out
Oh,
loud.
yes, I'm sorry. Yes.
I'm sorry, I just want to make sure I understood you correctly. All right, I'm going to allow her to return home. But ma'am, you can't possess a weapon, firearm, or ammunition. You understand that?
Yes, Your Honor.
All right, good luck. Good luck, sir. Thank you. Please tell me your name.
Sandy Brokenborough, good morning.
Good morning. 21MM 295. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Why doesn't she qualify for pretrial release?
Sandy Brokenberg,
She has a history.
yeah, with 3 DOCs, several VOPs, just her history, Your Honor.
All right, your bond is $500. You can't have any contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You have to maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. So if she's not living there, you can, but if she's still living there, you cannot. You understand that?
She's a 17-year-old child, so I pay the bills and she can stay there without.
Yes, because right now, without her testifying in court, I'm not going to change that. So that's why I'm saying, if when you get there, she's not living there anymore, you can live in that house. I'm ordering you maintain a separate, so 2 separate residences. But if she's still there, you can't stay. So you're gonna go back one time with law enforcement to gather your belongings. All right, good luck, ma'am.
Thank you.
Please tell me your name.
Giselle Castro.
21MM296, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. She qualifies for pretrial release. Any objection from the state?
No, Your Honor.
At this time, I'm going to place you on pretrial release with special conditions. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. I'm ordering you to maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens while on pretrial release. Good luck.
Thank you.
Please tell me your name.
Daquan Lawson.
21MM4707, a warrant was issued for your arrest, charging you with violating a condition of pretrial release in a domestic violence case. Another judge has already found probable cause. I'll appoint an attorney to represent you.
Could I speak right quick?
You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am. I wasn't never bonded. I was never on pretrial release. I was bonded out. So pretrial release wasn't on my paperwork when I first got out on the 5th of July.
It says in the affidavit that at your first appearance hearing, you were ordered by the judge to have no contact with the victim, not return to the scene of the offense, not possess any weapons, firearms, or ammunition, and maintain a separate residence. So if you think you have some defense to this, you're going to have to talk to your attorney and raise that in front of the trial judge.
But what I'm saying is I bonded out. I wasn't on pretrial release.
Even if you weren't, you still violated conditions of pretrial release. If the judge orders you not to have contact, you can't have any contact, whether you're on pretrial release or not.
Yes, ma'am.
Your Honor, also, I don't know if information has been filed yet on his out on bond case. I have no information as of 7/9, unless state has information filed.
No, Your Honor, when I checked, it had not been filed yet.
All right, in this case, I'm going to set your bond at $5,000. You may not have any contact with the victim at all. Do you understand that?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't return to her residence for any reason. Do you understand that?
Yes, ma'am.
It doesn't matter if you're placed on pretrial release. As a condition of your bond, I am ordering these things. Do you understand them?
Yes, ma'am. I had a question on the bond.
Yes.
Could you lower it?
I will not at this time, based on your charges. I'm also revoking your bond in 21 CF 7055.
Even with the high bond on the PTR violation, Your Honor?
Yes. Good luck, sir.
Rodriguez Parish, East Behavior.
21MM3603. It's a warrant. I'm going to appoint the public defender's office.
We'll waive the appearance, Your Honor.
All right, another judge has already found probable cause. The bond will be $500. No contact with the victim, no weapons, firearms, or ammunition. He's not allowed to be within 1,000 feet of her residence, may not return for any reason, may not be within 1,000 feet of her place of employment. Hold on one second. All right. Please tell me your name.
Lori Walton.
21MM150. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Any objection to pretrial release?
No.
No, Your Honor.
At this time, I'm going to place you on pretrial release with special conditions. You can't have any contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. Were you two living together?
Yes, but he moved out.
All right, you can't live together now. I'm ordering you must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. All right, good luck. Please tell me your name.
Good morning. My name is Michael Edge.
All right, sir, you have a warrant out of Osceola County for violation of probation for trafficking in hydrocodone. There's no bond authorized on that. I'll appoint an attorney. That's 13 CF 4348, and then 13 CF 4337. You have another violation of probation for trafficking in hydrocodone, again with no bond. I'll appoint attorneys in both cases, and we'll notify Osceola that you're here.
Your Honor, he was only booked in on the 4348 case.
He's only here today on 4348?
Yeah, he only has one case he's here on.
What's 4337?
That's a hold. They didn't serve that, so we don't need.
Okay, so we don't have it yet? All right, so I'm sorry, only one of those has been served on you. I don't know if the other one is coming. But we'll notify them that you're here so they can come and get you.
Thank you, Your Honor. Just a moment to confer.
All right, good luck, sir. Please tell me your name.
Aaron McGallen.
Looks like you have a warrant out of Marion County in 18 MM 149 for violating probation on a charge of possession of cannabis less than 20 grams and possession of drug paraphernalia and expired driver's license more than 6 months. There's no bond on that. We'll notify them that you're here so they can transport you. What's the Palm Beach one? There's also a hold for Palm Beach.
Yes, it's another, I believe it's BOP, let me check.
That hasn't been served?
No, it's just a hold for them.
All right, it looks like you have another hold out of Palm Beach County as well.
Yeah, BOP for battery DV.
All right, I don't have that one today, so you'll probably be back on that one. All right, good luck, sir. Please tell me your name.
Kenneth Rosario Paulino.
You have a warrant out of Osceola County in 20 CF 19 for violating probation on a charge of grand theft from a dwelling. There's no bond authorized. We'll notify them that you're here so that they can transport you. All right, good luck, sir.
Thank you, Your Honor.
Please tell me your name.
Dontavia Smith.
Looks like you have a warrant out of St. Lucie County in 18 DR 991AX. It's a writ of bodily attachment. It looks like your purge amount is $1,000. So you do have a purge amount on it, but if you're not able to pay it, they'll come and get you. All right, they'll come and get you and transport you back down there. Good luck, sir. I don't have that. Please tell me your name.
Jonathan Crawford.
You have a warrant that was issued for your arrest in 18 CF 12812 for violating your probation by committing the criminal offense of battery domestic violence and having hostile contact with the victim or the victim's family. There's no bond authorized on that warrant. I'll appoint an attorney to represent you. Does he have another one? No, that one's not here today?
Yeah, that's
All right.
already been seen on that one.
Your Honor,
Yes, sir.
may Mr. Crawford be heard?
I have two dependents at my house. I mean, at my apartment. I'm renting an apartment and I have a job. Can I have a bond?
No, not on, I can't give you a bond. Your attorney's gonna have to file a motion in front of the trial judge in this.
And do you know what time? I mean, what day would it be?
Well, that's up to your attorney. So call that number and ask them to file a bond motion right away.
Yes, ma'am.
Yes, sir. Good luck. All right. 2019 CF 7370 is a violation of probation with no bond. I'll appoint your office, Mr. Brantz.
We'll waive the appearance, Your Honor.
And then in 21 CF 8212, there is probable cause. I'll appoint your office.
We'll waive the appearance on those charges as well.
All right, her bond, I'll state at 1,000 and 100, not have contact with any known drug dealers, not possess or consume any controlled substance without a valid prescription. I'm going to revoke her out on bond case 21MM552.
Would you consider no action as, did you set a bond on the VOP? Was it no bond on VOP?
No, it's no bond.
If she's already being held on the VOP, would you consider
Right.
no action on the out-on-bond case? As the current charges of possession, relatively nonviolent and unrelated to the battery, no victim.
Right, but it is related to her VOP. She was on probation for a felony DUI. So it appears there's a pattern of substance abuse and an inability or an unwillingness to follow court orders. And since the battery is a violent case, what says the state?
Your Honor, as she's already been held no bond, I actually don't have an objection to her getting revoke and double on the battery.
All right, I'll revoke it and double it. So it's 500, now it'll be 1,000. Please tell me your name.
Terrence Pugh.
20 CF 5564. A warrant was issued for your arrest for violating your probation by failing to complete the aggressive driving class as ordered, failing to complete the victim awareness program as ordered, and by failing to live without violating any new law by committing the offense of driving while license suspended.
Can I say something?
You can say anything you want, but everything you say is being recorded and can be used against you later. You understand that?
It was pertaining to the.
There's no bond on the warrant that was signed by another judge, but it sounds like you think you may have some defenses, so get in touch with your attorney right away so that they can raise those in front of the trial judge. Okay? I did appoint them, right? I'm appointing them. All right, good luck, sir. I don't know who that is.
Showed up.
Okay, you have it? have what I ordered. All right. Please tell me your name.
Corey Walton.
21MM150, we previously addressed it. It's a battery case. Sir, do you wish to testify?
Sure.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record and spell your last name.
My name is Brandon Capleton, and my last name is spelled Capleton.
All right, I'm going to let the prosecutor ask you some questions.
I apologize, the defendant's name?
Thank you.
Good morning, sir. Sir?
Good morning.
Hi.
Yeah.
How do you know Miss Walton?
We were dating for a while.
Has something like this happened before?
Yes, it has.
While this case is pending, would you like to have contact with her?
No,
Are you afraid of her?
no.
I have no further questions.
Mr. Brantz?
No questions, Your Honor.
All right, thank you, sir. Is there anything else you'd like to tell the court today?
No. Well, I guess I would want to try to figure out how we get through restraining order processes, because I do want her to be as far away from me as possible. So I would want to do that.
So what I ordered, I placed her on pretrial release. I ordered she's not allowed to have any contact with you and that she can only return one time to the residence to gather belongings with law enforcement.
Okay.
So at this time, she can't have any contact with you.
Okay.
If you want to file for an injunction, you're going to have to talk to the state, or do they go to the courthouse? You go to the courthouse to do that.
Okay. Thank you.
All right, thank you for coming. Thank you, ma'am. I'm not changing the order for anything. Yes,
He no longer lives at the residence.
that's fine. I ordered you to maintain a separate residence. So if he doesn't live there, you can. But if he lives there, you can't. Because the court doesn't have jurisdiction to order him to leave. Is the state ready for 33-day motions?
Yes, Your Honor.
All right, go ahead.
Mark Anthony Bernardo, 21 CF 6321, denied. Information was filed. Richard Rivera Pagan, 21 CF 6792, granted. Notice of non-filing. Luis Omar Cruz Avila, 21 CF 6877, granted. Notice of non-filing. I have note here that Lanal Aaron Abercrombie, 21
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Good afternoon, Madam Interpreter. I'm here at the BRC. Can you see if we can make a connection with the podium, please?
There is contact, Your Honor.
All right. Good afternoon, sir. Can you tell me your name?
Manuel Ramos Rodriguez.
Manuel Ramos Rodriguez.
Mr. Ramos Rodriguez, you are here this afternoon for arraignment in case 2021 MM 4669 AO. You've been charged in a 2-count information by a charge of battery in count 1 and criminal mischief in count 2. Count 1 is a first-degree misdemeanor, is punishable by 1 year in the county jail and a $1,000 fine. Count 2 is a second-degree misdemeanor, punishable by 60 days in the county jail and a $500 fine. You are represented by the Public Defender's Office. Mr. Brands, what plea you want to enter on behalf of your client?
Not guilty, Your Honor.
Sir, I'm going to accept your plea of not guilty in this matter. We're going to set you for pretrial conference and trial in Division 50 on
August 16th, 1:30 p.m., class C.
All right, sir. Have a great day. Well, one more question. Do I have any more Spanish cases other than that one last one? All right. Well, thank you, Madam Interpreter. Thank you for your help this afternoon.
Thank you, Your Honor.
All right, now we're on to 2021 MO 689 AO, and you were telling me about Mr. Stoglin. All right, he's represented by the Public Defender's Office. Would you like to do his case?
We'll waive the appearance and enter a plea of not guilty, Your Honor.
All right, we're set for Division 63 on the following dates.
Division 63, pretrial conference is August 12th, 1 p.m., courtroom 12C.
All right, Mr. Jeter is supposed to be here in 2 matters. The first one is 2021 MM 1724 AO, as well as 2021 MM 419 AW. I want to appoint a public defender to represent him in both of these cases.
We'll waive the appearance, Your Honor.
As to his failure to appear case in 2021 MM 1724 AO, going to state a bond amount of $2,000. As to his new case, 2021 MM 419 AW, I want to set bond amount, count 1 amount of $1,000, count 2, $100, condition of the bond, no contact with any victims or witnesses, no return to the scene, no weapons or firearms. Any weapons or firearms he has needs to be returned to law enforcement in 24 hours of his release. Also, no contact with any witnesses. There it is. Good afternoon, sir. Can you tell me your name? Mr. Hunter, you're here in case 2021 MM 4798 AO on a charge of battery. They reviewed the charging affidavit in your case. Did find probable cause for your arrest as to that charge. We're going to set your bond in this, say your bond in this case amount of $500. Condition of your bond that you not return to the scene, the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You also may not have any contact with any victims or witnesses while this case is pending. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
I want to ask one thing,
Yes, sir.
for $500, I mean,
Well,
you have to return back to that place where I was citation at.
yes, sir.
How do I go back and not go back?
Do you have things back there at that location?
Items everywhere.
All right. Well, at that location, do you have anything that you need to return to get back to you?
Every second of the day.
All right. Do you have items at the location that you had that you need access to?
Items right there, right?
Okay, I'll do this. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the location. After that happens, you can't go back, all right? Have a great day.
One more thing, officer. Now, I haven't had my medication.
Yep.
I mean, I know you're not a medical attorney or anything like that, but I haven't had my medication, my injection, my Haldol, any medication since I've been here in the city with my medication.
Okay.
I have chemical imbalance and I'm all unstable, but I want to say, I haven't had anything to smoke. I had vape cigarettes and all that, all the above and below. And have a good day.
Well, I need you to make sure, like you meet with the medical staff before you leave. Either you get that medication or you go by Aspire and make sure you can try to get that medication. I can't force them to give you medication. That's outside my jurisdiction. All right. Have a great day, sir.
Jimenez, she refused court.
All right. This is 2021 MM 4793 AO. Elizabeth Jimenez, I'm going to appoint a public defender to represent her.
We'll waive the appearance, Your Honor.
All right, Ms. Jimenez is here in 2021 MM 4793 on a charge of trespass on property after warning. Did review the charging affidavit, found probable cause for her arrest. Gonna The bond is $500, going to stay that. Going to make a condition that she not have any contact with any victims or witnesses and no return to the scene or location. She's out on bond on several charges. First being 2021 CF 6107 AO, as well as 2021 CF 804 AO, 2020 CT 4607 AO, as well as 2021 MM 3011 AO.
Your Honor, I believe she may be incompetent to proceed in some, or if not all of those cases. I would have you take no action on those.
Has she been determined to be incompetent or not?
If you give me a moment, I can confirm. I can't find confirmation, Your Honor. I had notes that said he was incompetent to proceed, so it is in your discretion, Your Honor.
Well, if that is determined later on, I may change her release conditions, or you guys can file appropriate bond motions that she may qualify for mental health pretrial release. But without that, the court's going to revoke all those bonds, set new bonds at $0 in those cases. Going to appoint a public defender if she doesn't have them in any cases that she's not already appointed. All right, it's 2020 CF 4713 AO. Going to appoint a public defender to represent Ms. English.
Waive the appearance, Your Honor.
She's here for a failure to appear warrant in that case, 2020 CF 4713 AO. Going to say her bonds at $0. Oh man, only person who wants to see me is Lyle. I said the defense attorneys don't people want to see me today. All right, this is Amber Fox. She has two cases, 2021 CF 8202 AO, and as well as 2021 CF 8223 AO. Going to appoint a public defender to represent her in those two cases. Are you going to waive her appearance, or
Oh, I'm
what you want to do?
sorry. Yes, we'll waive her appearance, Your Honor.
All right. I reviewed the charging affidavits in both her cases, did find probable cause for her arrest. I'm going to check her bond. As to 2021 CF 8202 AO, want to stay her bonds, $2,500, $500 and $250, condition of the bond, no return to the scene, no contact with any victims or witnesses, no weapons or firearms. The weapons or firearms she has needs to be turned over to law enforcement within 24 hours of her release. She may not possess any drugs or alcohol without a valid prescription, subject to random drug and alcohol testing. 2021 CF 8223 AO, going to state a bond on that, $1,000. Same conditions, no return to the scene, no contact with any victims or witnesses, no weapons or firearms, and no drugs or alcohol random testing. All right. Good morning, good afternoon, sir. Can you tell me your name?
My name is Carlos Powell, sir.
Mr. Powell, good. And counsel, can you put your name on the record?
Jonathan Rose on behalf of Mr. Powell, Your Honor.
All right. So, Mr. Powell, you're here in case 2021 CF 75980 on charge of fleeing and attempted to elude law enforcement. The judge signing your warrant in this case has already found probable cause for your arrest. They set your bond amount of $2,500. Make a condition, I'm going to say that bond, make a condition that you not operate a motor vehicle without a valid driver's license. And I guess, Ms. Rose, you want to talk to me about his out-on-bond case, I'm guessing.
That's correct.
And what do you need to tell me about his out-on-bond case and why I should not revoke it?
Well, formal charges were just filed yesterday by the state attorney's office. He was actually charged with third-degree felony possession of fentanyl and possession of drug paraphernalia. With respect to that case, I have an email from his bondsman who bonded him out on this case. indicating that she is going to stay on that bond. If I have a copy of that for the court in the state, should the court want to see that. And with respect to the other issues, Judge, he has been in Orange County for the past 29 years, moved here in 1993, is my understanding. He's a homeowner, he has 3 children, 2 who are minors and live with him. Court needs to be aware that he has some serious medical issues. He has a compromised bladder and a compromised colon. So in order to urinate, he has to catheterize himself. He came here with a catheter. He hasn't been given a new one since he's been here. He doesn't have the proper supplies to catheterize himself. So it is both, he's risking infection, and it is very difficult since he doesn't have the appropriate supplies to catheterize himself with, if you understand what I'm saying.
Has he seen, well, when he went to medical, when you came here, did he explain to them what he needed? And I'm quite sure they're not going to give him those supplies to be out in general population. They're one of the long tube that could be used for other reasons other than to catheterize himself. So quite sure that would be a reason not to give him that while he's out behind back in the general population. But I'm quite sure if he goes to medical, they will assist him, or he can assist himself in making sure that he can relieve himself.
But
I just want to make sure that I'm got the correct information, right?
Yes, well, he came aboard with his own catheter, and he hasn't been given a new one. He's not supposed to, as you can imagine, reuse a catheter. So he's probably got an infection already. He's at risk of further infection. He also, because he has damage to his colon, he wears an adult diaper, if you will.
Yeah.
So given his medical conditions, the fact that his bondsman is willing to stay on his bond, the nature of the alleged offenses, I would request that the court either not take any action on the bond on his original case, or if the court is inclined to revoke and set a new bond on that matter.
All right, so counsel, based on the statute, which will be 903.046 and 903.0471, how am I supposed to view this? I'm looking at, I have a defendant is here for a new law offense, which is essentially failure to comply. He's out on bond on another offense. He has 8 felonies, 5 misdemeanors, 5 failures to appear, various other arrest and conduct that would be considered concerning to the court. So how am I supposed to interpret that? I mean, as in, we have to make sure he has to appear, to make sure he doesn't violating the law, to make sure that I'm keeping the community safe. Those the main 3 things in those statutes that it tells you I have to consider. So address those 3 things. I mean, I can tell he's been here for a while because his history goes back probably into the late 90s. So he's been here for a minute. So he has established history in the state in Orange County. But outside of that,
Judge, in terms of his willingness to come to court, and I think it should be noted that he turned himself in on the warrant yesterday. He was not arrested on the warrant.
Okay.
With respect to, so he is not a risk of fleeing. He is a homeowner. He has family here. He has children. With respect to the community, I do think it's worth noting, Judge, that you have to go back to about 2013 since he has a felony conviction. I think that the last conviction he has before these 2 cases was in 2015, based on my review of his criminal history, which was, if I'm not mistaken, a NVDL, if you will.
Yeah.
So though he does have a significant criminal history, it's been 8 or so years, by my calculations, he's had a felony conviction. That the charges that he has one is simple possession of a drug, and the other is a 3rd-degree felony, not high speed fleeing, as alleged in the affidavit. So I would certainly say that he is not a danger to the community. He is not a flight risk.
all right.
And he does have significant medical issues, which are going to be an issue.
All right, you say he has 2 counts now? Because I think his original arrest on the other case was 1 count, correct? Or is it 2?
No, I have the information. He was charged with possession of fentanyl and possession of
I
drug.
was gonna make sure I'm going to give him appropriate bonds if I'm, all right. All right, Mr. Powell, I am going to revoke your bond. That's the count 2021 CF 5284AO. I'm going to set a bond in that case. I'm going to set your bond on count 1, amount of $10,000, count 2, $10,000. Condition of that bond should not possess any drugs, or alcohol without a valid prescription. You be subject to random drug and alcohol testing. You're also not allowed to operate a motor vehicle without a valid driver's license. You already have Mr. Rosen representing you? All right,
Yes.
have a great day, sir.
I'm sorry, Your Honor.
So I told him, everybody have a great day.
Very good. Thank you, Your Honor. Have a great afternoon.
All right. Kathleen, sir, can you tell me your name?
Wyatt Walker, sir.
Mr. Walker, you're here in case 2021 CF 7334AO on charge of racketeering and in count 2, conspiracy to racketeer. Judge signing your warrant, this case has already found probable cause for your arrest. Now, statewide, did you want to tell me something, or?
Your Honor, Statewide just here making my presence, Mary Salmon, on behalf of the Office of Statewide Prosecution.
Good morning, Your Honor. Lyle Mason, how you doing? Good morning, Your Honor. Lyle Mason on behalf of the defendant.
All right, Mr. Mays, I wasn't sure if you were coming back.
I made it.
All right. All right, Mr. Mason, you want to tell me anything?
Yeah, so
Or,
we have two issues. One, you actually just addressed with the former case, so I'd like to address that while it's fresh in your mind. This defendant is currently out on another bond. I'm sure the court's aware of that, correct?
Yep.
Okay. As to that, my argument is that the alleged predicate acts in the RICO statute, none of the acts that my client have committed happened since his release. He was released on bond
on the 1st of January 21st,
January 21st, 2020. So none of the acts that are listed in the affidavit are actually occur after that. So to that end, I had actually spoke with the prosecutor. I believe that she's in concurrence with me that to that end, that she's not objecting to the court not revoking the bond in that case.
Okay. Is that
Defense
correct?
counsel's assessment would be correct, Your Honor, that the predicate acts that encompass the RICO.
Obviously.
You're always welcome here.
All right. Judge McGinnis is here to sign warrants. All right. All right, so you're saying the court was without jurisdiction to take action on his 2021 CF 538AO case because any acts were not committed technically while he was out on release.
Correct.
All right. And everybody's in concurrence with that. So I won't take any action in 2021 CF 538AO.
Thank you. The next issue is the bond. So the bond is $750,000.
Correct.
To that end, the court, I have two witnesses I want to address because we do want to address safety of the community as to whether or not any continued criminal acts are taking place and whether or not this defendant is going to appear. I have two witnesses I'd like to address that with. But I guess I'll call them first. Let me call Mr. Mike Pierre.
Well, I'm going to tell you this. Under, what is it? Was it the presale statute is 0471? It's got the discretion to have the bond hearing, or I choose not to.
It's
in this particular case, as I've seen now, how many people now? Almost 20 defendants. I think only one that has had their bond modified is because the state agreed to it. If states agreeing to me modifying these bonds, I'm not really.
So the state, in this case, the state is not agreeing to, but I'm confident that the court will reconsider the price of this bond if the court was to hear the testimony. I could briefly proffer what the testimony was going to be.
No, my thing is this. You may want to take this up with the division judge that's going on downtown, because at this hearing, as I was not going to move the bonds unless the state had agreed to, because I'm not going to exercise my discretion to hold a bond hearing right now. So I was telling you right now, you can call your witnesses, but I'm not exercising my discretion, so you can formulate what record you need to. I'm not gonna stop you from doing that, but I just want to be candid with you that I'm not going to exercise my discretion to have that bond hearing.
Okay.
What I plan to do is keep the bonds as set, make all the same conditions, no contact with any co-defendants, no contact with any known drug dealers or drug users, no weapons, no firearms, or weapons or firearms need to be turned over to law enforcement. That he is to comply with Florida Statute 903.046 sub 2 sub F, and that whoever is to pay his bond premium needs to come file a affidavit with the court attesting that the funds used to bond him out did not come from an illicit source, including the activity of which he's
Repeat
committed.
that, Your Honor.
Florida Statute 903.046 sub 2 sub F is basically what we used to call Nebia, but it doesn't have we don't have the same requirements as the federal government, so you have to have a hearing.
So understand, so I know the NBA they got outlawed, but you're asking that the bondsman do something on top of accepting the bond?
Correct.
And what was that?
Is that you file an affidavit with the court attesting that the funds used to bond that person out did not come from any illicit source. So whoever's paying the bond premium. So you're not required to have the hearing. I don't need to see them again, but as long as they filed the affidavit, the clerk should accept his bond and should be able to keep it moving.
That's understood, Your Honor. And just before you close the hearing, enter your full ruling, because I don't want to speak after you rule. As you discussed, you have discretion as to whether or not to hear the bond.
Right.
If I just want to speak as to my argument as to why I would ask the court to use its discretion and not actually get into you doing discretion yet. May I do that, Your Honor?
Yeah, I just want to give you my mind frame.
Okay.
There's some, like I said, I think 20-something defendants involved in this case.
Understood.
It seems to be unfair in a sense where half of them were not represented at the time of this hearing, other than I appointed public defender. Some people came in with, like yourself, private defense attorneys.
Understood.
Seems to be unfair at this point for me to be moving bonds without that person talking to the division judge who's in charge of managing this entire case and all those kind of things like that. So I feel like it's an unfair benefit at this point to do that. So we can, like I said, the division judge, that's an absolute requirement that they have that hearing for you and consider all those things like that. You know, danger to the public, flight risk, you know, whether he's going to show up to court, all those kind of things like that. Because of the number of people, I just think it's an unfair kind of
I
situation.
fully understand what this court's trying to say. It wants to do equal justice for all. The issue with bonds is that each defendant is unique.
Right.
I don't want to punish this defendant because he does have a lawyer and now it goes up. Well, getting a lawyer doesn't help you out. You're just going to sit here and go to the next judge. And then, thank you, you didn't take any action on revoking the other bond, so thank you for that, so that does work. But I just wanted to address this one, how he's unique versus the other defendants, in that where the court's concerned about ongoing criminal activity, if the witnesses that the defense would intend to provide would show this court that despite that he's wrapped up in this RICO case, Mr. Walker has been gone and out of here for the last year and a half. And he's not just been gone and missing from town. The gentleman with his hands on the window, the rather large man staring to his left, is literally his personal overseer. He goes with him everywhere, every place, can testify to everything. There is, in the state's own exhibits and documentation, there are gang members through the text messages that are complaining that he's not here. If you were to look at page 344 of their Exhibit A, there's literally people within this RICO statute complaining that he's never here. When he shows up, he literally does a concert. He's with police, he's with security, and he takes off, and they're complaining about that. So for this defendant, the issue is, I think, one, the court will be satisfied that he's far enough removed that he's no longer a continued danger. Two, if the court actually looks at what he's charged with, the charges that are his predicate acts, they are possession of a firearm, which he's currently charged with, as we discussed, and grand theft. There was the possession of firearms, a case that's been dismissed, and possession of the sale and delivery of cannabis, possession of tetracannabis has also been dismissed. So there's essentially one case pending left. So my point is,
There's a reason for that, because it'd be, hard for them to bring a RICO charge if they're continuing a prosecution outside of that statute. I think the case law is unfavorable to them if they tried to do that.
Completely understood. The issue, though, is a $750,000 bond, which essentially does to him one or two things. You guys are sitting here until we can get you in front of another judge, or for lack of a better, we are giving a bondsman a Tesla. I mean, that's kind of where it's at. So if I was able to convince the court that the community was safe, then I think the court would consider it. The other issue is I had the, sorry, I got one moment so I say the correct person. The head of this investigation did a press conference, which I have as evidence for the court where I showed they saw it.
Right.
They specifically said during the case, going, the reason we charge people with RICO is so that they can't afford to get bonds to get out, and then they stay in jail, and then we can convict them. That's just unconstitutional. I mean, that's an issue. And that's why we have a $750,000 bond on a kid who has a grand theft, providing false ID, and a gun charge. That would be a $5,000 bond in any other condition.
Well, probably a little more than that, but.
Oh, I mean, $20,000. So I'm asking this court not to drop this bond down to $5,000 or $50,000, but at least make it something where it's a reasonable, in some degree, reasonable for a kid who's never here, hasn't been here in a year and a half, has a personal manager who's, I mean, literally can count for his every move. His mother moved down with him to Miami, took him to Miami. She's down there, can account that she sees him every single day. He's zero danger to this community. He might have done some things with his videos of him on Instagram and stuff like that. It's a shame that that's what our culture promotes, and that's how we market people. But he's now actually got a huge career with different record labels representing him, and he's doing well, and he hasn't been here in a year and a half. There is no danger. I'm confident. I mean, believe me, Your Honor, half of why I want these guys to speak isn't even for necessarily even just you. I want the prosecutor to get the chance to hear how good he's doing.
Your Honor, the state would just ask that, Your Honor, stay the bonds as is. I don't speak on behalf of the director of the MBI, but I think that was a mischaracterization of the statement he made during that press conference. But the state, nonetheless, will ask that, Your Honor, stay the bond.
No, like I said, you can call your witnesses. I'm not going to stop you from doing that. I'm just telling you that, like, if you file a bond motion, so a judge in the division should hear that within the next 5 days, and you should be on your way to just laying out all those kind of things like that, and that judge is managing that case.
Fair enough. But I mean, I'll give
Make
two
that
responses
decision.
to that then. If the court's saying that regardless of me calling the witnesses that doesn't want to exercise his discretion, I'm not going to take this court's time. I'm not going to do that. So that I won't do. And then second, again, so I'm not mischaracterizing. I was in some saying what it was. I'm not saying that this is what the goal is of MBI, or they're purposely trying to deny people constitutional rights. What it is for me is it's a backdrop to showing that's why this is so important, like to make sure people don't get stuck in jail. It was a good
There
layup
is
and an argument.
great history and articles written, law review, and some documentaries and movies about RICO statutes and their utilities and creations, going back to Al Capone. So, it is what it is as far as that.
Fair enough.
I want to say the bonds that's set in the case. Like I said, no co-defendants, no gang members, no drugs, no alcohol, no weapons, no firearms. Weapons and firearms you have need to be returned to law enforcement within 24 hours of your release. Also, the person, whoever is bonding, paying your bond premium, according to the statute 903.046 sub 2 sub F, needs to file an affidavit with the court attesting that these funds did not come from any other illicit source, including the charges including this RICO case, not just your particular charges you're facing. Did I miss anything? All right. And you can, like I said, I think the admin order says that you guys should be seen probably in the next 5 days. If you file one this afternoon, you should maybe be seen tomorrow.
Understood.
All right.
Thank you, Judge.
All right. Have a good day.
All right. Thank you very much, Your Honor. Good to see you.
Good to see you too.
I'll go out and post the bond.
Hope your mom's doing better.
Thanks, man. I appreciate it.
Mr. Moore, not talking to me either? Okay. I was like, man, I'm about to get depressed up here. Only person want to talk to me is Sunshine today. May have lost Mr. Moore. That's case 2021 MM4800AO. Mr. Morrison is here on charge of criminal mischief. Going to appoint a public defender to represent him.
Waive the appearance, Your Honor.
All right, going to release him on mental health pretrial release. If he does not qualify for mental health pretrial release, going to set his bond amount of $150. No return to the scene, no contact with any victims or witnesses. No weapons or firearms. The weapons or firearms he has needs to be returned to law enforcement within 24 hours of his release. Sorry. All right. Good afternoon, sir. Can you tell me your name?
James Moore.
All right. Mr. Moore, you're here in case 2021 MM4794AO on charge of petty theft. They reviewed the charging affidavit in your case. They find probable cause for your arrest. Going to set your bond, in this case, amount of $500. Condition of bond, it should not return to the scene of the location. You may not return to the scene of location, no contact with any victims or witnesses. We're going to appoint a public defender to represent you in this case. You have a great day, sir. All right, good afternoon, sir. Can you tell me your name?
Maul Reese, sir.
Mr. Reese, you're here in case 2021 MM4799AO on charge of resisting officer without violence. They reviewed the charging affidavit. They find probable cause for your arrest. Going to set your bond in your case amount of $500. Condition of your bond. You should not return to the scene of the location. You're out on probation. I think there's a warrant already out for him.
That is the hold for him.
Yep. So you got a hold from Seminole County for probation. May see you on that warrant, or may get you on to Seminole County. Have a great day.
Yes, sir.
You have a warrant for your arrest for violation of probation from Seminole County.
Yes, sir.
I don't have that warrant in front of me, so either I'm probably going to see you tomorrow, or you'll be sent to Seminole County before I get to see you. All right, have a great day. Good morning, sir. Can you tell me your name?
Ryder Westmoreland.
Mr. Westmoreland, you are here in case 2021 MM151AE on a charge of trespass on property other than restructure or conveyance, refusal to leave. Viewed the charging affidavit, did find probable cause for your arrest. Was there an offer that was discussed with Mr. Westmoreland?
Withhold of adjudication, credit time served, and no return to the location.
All right,
Yes,
Mr.
Your Honor,
West.
I had a chance to speak with Mr. Westmoreland in the back, and we do have some defenses, and I would request ROR as,
Let's talk.
I don't know if he receives mail, but he does stay often at the Union Mission or the Salvation Army. And I was hoping that if we can get a court date from Madam Clerk today, that I can write that down on our public defender sheet, and he has assured me that he will show up on that date.
Well, that's a question. Like, do you, Mr. Westmoreland, for me to release you on your own recognizance, kind of need somewhere they can mail you stuff.
I just moved here, man, so I don't
Yep.
I don't have a stable,
That's my next thing about releasing him RR is that he seems to be from Georgia.
Yeah.
And has no real established ties here to the Central Florida community. But you don't have an extensive criminal history. I can reduce your bond. I'll reduce your bond to $50, condition your bond that you not return to the scene of the location, have no contact with any victims or witnesses. But just forewarning you that, they arrest people regularly for trespassing, camping, no, not camping so much anymore, but all types of disorderly conduct and various other crimes like that for being homeless. So just be careful out there. All right, gonna appoint the public defender to represent you. Thank you. All right. Good afternoon, sir. Can you tell me your name?
Rochelle Gordon.
Mr. Gordon, you're here in case 2021 MO789AO on charge of open container. Did review the charging affidavit in your case, did find probable cause for your arrest. I believe the city of Orlando is offering a withhold of adjudication of guilt and court costs to resolve your case today. Would you like to do that?
No, please no contest.
Yep.
I spoke with Mr. Gordon in the back, and I believe he wishes to.
Okay. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down, sir. Sir, you're here in case 2021 MO789AO on charge of open container. That is a first, second degree misdemeanor. It's punishable by 60 days in the county jail and a $500 fine. Do you understand that?
Yes.
You said earlier that you want to enter a plea of no contest. Is that still correct?
Yes.
You understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form that's in front of you. Well, I'll tell you what the form says. Sir, do you understand you're waiving your right to have a trial? You're waiving your right to contest the evidence against you and call witnesses on your behalf. You're also waiving your right to have an attorney present in this case. Do you understand that?
Yes.
You're also waiving your right to remain silent and to appeal any errors in this case. Do you understand that?
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
I'm not.
You understand if you're not a United States citizen, you can be deported from this country?
Yes.
All right. I did review your charging affidavit, did find a factual basis contained therein. I'm going to accept your plea of no contest, find your plea is freely and voluntarily entered. I'm going to withhold adjudication of guilt. I'm going to give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. This court costs, in this case, amount of $223. I'm going to give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you, sir.
All right, I have Martinez bonded. Good afternoon, sir. Can you tell me your name?
John Welcher.
Mr. Welter, you're here in case 2021 MO791AO on charge of disorderly conduct. Did review the charging affidavit, did find probable cause for your arrest. I believe the city of Orlando is still offering that withhold of adjudication of guilt and court costs like they did the last time. Did you want to accept that offer from the court, from the city at this time?
Sorry, I'm hard at hearing.
Did you want to did you want to accept the city's offer? Sorry, water was going down the wrong way. Do you want to accept the city's offer of a withhold of adjudication of guilt and court costs?
Yes, sir.
All right. Well, those can help you hear better if you're having problems hearing me. All right, can you raise your right hand and be sworn in?
Does that mean,
Yep, you'll be leaving unless you have any other charges.
thank you.
All right. Do you solemnly swear or affirm the testimony you're going to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Put your hand down. So you're here in case 2021 MO791AO on charge of disorderly conduct. I did review the charging affidavit, and that is a second-degree misdemeanor, and it's punishable up to 60 days in a county jail and a $500 fine. Do you understand that?
Sure.
Do you want to enter a plea of guilty or no contest to resolve your case with me today?
No contest.
You understand by entering a plea of no contest, you're going to waive all the rights outlined on this plea form that's in front of you.
Yes, sir.
Do you understand by, are you under the influence of any drugs, alcohol, and medication?
Yes, sir.
Are you under the influence of any drugs, alcohol, and medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
Yes, sir.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yes, sir.
I had an opportunity to review a charging affidavit, did find a factual basis contained therein. I'm going to accept your plea of no contest, find your plea is freely and voluntarily entered. I'm going to withhold adjudication of guilt. I'm going to,
Yes, sir.
I'm going to give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court costs in this case are $223. I'm gonna give you 2 years from today's date to pay that money directly to the clerk in full. You got 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir. 13th, right? All right, sorry. Somebody must have cleaned this today. It's like sliding, like. All right, this is 2021 CF 8222 AO and 2021 CF 8207 AO. We're going to appoint a public defender to represent Mr. Algery.
Can we reset till tomorrow, Your Honor?
Was there,
I spoke to him in the back. I don't know why he refused court, Your Honor.
do I know what happened to him? Mr.
Give me a moment.
Let's say that's the 8222 AO, count two, I found a PC for attempt.
Okay.
Attempt. It's a destruction of evidence.
Agreed, Your Honor.
No argument.
Okay.
What I said to him, what to help him besides that, but I suppose we'll waive the appearance, Your Honor.
If you, some people just might not like to hear what you got to say, Mr. Bronson. It's gonna be the story of your life
Yeah,
as an attorney. All right, as a 2021 CF 822 AO, count one did find probable cause, count two found probable cause for the lesser included offense of attempted destruction of evidence. I'm going to set his bond in count one amount of, I guess, $5,000. Count two, we're going to state a bond amount of $150. No return to the scene, no drugs, no alcohol, without a valid prescription, no drug dealers or drug users. That's 2021 CF 8207 AO. Did find probable cause for his arrest as to that charge. Going to state his bond amount of $4,000. Condition of his bond, no weapons, no firearms. Any weapons or firearms he has needs to be returned to law enforcement within 24 hours of his release. He's out on bond in another drug case, another weapon case in 2021 CF 2429 AO, as well as 2021 CF 3984 AO. As to those bonds, going to revoke them, set them at $0.
Hello, Your Honor.
All right, good afternoon, sir. Can you tell me your name?
My name is Alexander Asensio.
Mr. Asensio, you're here in case 2021 CF 8206 AO on charge of grand theft motor vehicle, burglary of an unoccupied dwelling, and resisting officer without violence. You reviewed a charging affidavit in this case. Did find probable cause for your arrest. Going to set your bond in count one amount of $150. Count two, going to set your bond amount of $5,000. And count three, going to set your bond amount of $100. Condition of your bond is you're not allowed to have any contact with any victims or witnesses from this case. You also may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And you're also not allowed to return to the scene of the location where this incident happened. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
Your Honor, I
Sir.
have one request. Can you lower the bond of the 4,000 to at least two?
Well, for some reason,
Can't
law
afford.
enforcement
Yes.
switched your counts. Count 2 is actually the higher offense and actually carries a $5,000 standard bond. Count 1 did carry a standard bond of $1,000. I reduced that down to $150 and $100 as your other bonds. You can always go in front of your division judge, as your public defender, file a bond motion on your behalf.
No, I
if you
don't.
think the bonds are
I don't know why I
unattainable
didn't
to you.
I don't know why I didn't get a.
Say again?
I don't know why I didn't get a defender.
I appointed you an attorney, so he can represent you. So that green sheet of paper has a number on it, you need to contact them, and they can get you in front of your division judge to have a bond hearing if you cannot afford your bond. All right. Good afternoon, sir. Can you tell me your name?
Luther Coleman.
Mr. Coleman, you're here in case 2021 CF 8218AO on charge of attempted burglary of a dwelling and criminal mischief. I did review the charging affidavit in your case. I did find probable cause for your arrest. 1 second here.
Read that again.
And count 1, I'm going to set your bond in the amount of $250,000. And count 2, going to stay your bond amount of $100. Condition of your bond is you're not allowed to return to the scene of the location, have no contact with any victims or witnesses. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Ando Cruz Hernandez.
Sir, you're here in 3 matters. The first one being 2020 CF 8787AO on charge of grand theft as a scheme. The judge signed your warrant in that case, set your bond in the amount of $1,000. Your bond is going to remain as set. I'm going to make a condition that you not return to the scene, the location, and have no contact with any victims or witnesses. You also were arrested in a warrant for case 2019 CF 11863AO for a charge of petty theft with 2 prior theft convictions. Judge signed your warrant in that case, set your bond amount of $1,500. The bonds remain as set. No return to the scene of the location and no contact with any victims or witnesses in that case. You also have case 2019 CF 11861AO. In that case, you're charged with retail theft of $750 or more as a coordinated effort. Judge signed your warrant in that case, set your bond amount of $1,500. Your bonds remain as set in that case. Condition did not return to the scene of the location, have no contact with any co-defendants or witnesses in that case, and want to appoint a public defender to represent you in all 3 of your cases. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Omar Lerone Dean.
Mr. Dean, you're here in 2 matters this this afternoon. First one being 2020 CF 3924AO on a charge of failure to appear. The judge set that bond in an amount of $0. The bond is going to stay as set on your failure to appear. You're also arrested in case 2021 CF 8216AO on charge of possession of MDMA or ecstasy and tampering with physical evidence. I found probable cause as to count 1. That's the count 2. Found probable cause for attempted tampering. Going to stay your bond, set your bond at count 1 amount of $1,000. Count 2 is going to be $150. Condition of your bond is you're not possessing any drugs, alcohol without valid prescription. You may not associate with any known drug dealers or drug users. State, can we resolve this trespass case in 2019 MM 7728AO?
No, Your Honor, there's a competency hearing that's set for next month.
All right. So I'm not gonna take any action in 2019 MM7728 AO. You have a great day, sir.
I have a bond at all on the,
Yep, you don't have a bond that's to your failure to appear, that's correct.
a bond on that, sir.
Now on your failure to appear. All right, have a great day, sir. Oh, did I give you more than one case? Sure. Okay, we're good. No, we're good. Thank you. Good afternoon, sir. Can you tell me your name?
Yes, Corey Manuel.
Mr. Emmanuel, you're here in case 2021 CF 8219 AO on a charge of possession of cocaine and possession of drug paraphernalia. I did review the charging affidavit in your case, did find probable cause for your arrest. We're going to set your bond to count one amount of $1,000 and count two $100. Condition your bond that you not possess any drugs or alcohol without valid prescription. Be subject to random drug and alcohol testing. And do not associate yourself with any known drug dealers or drug users. In this case, I'm going to appoint the public defender to represent you. You have a great day, sir. That doesn't look at Mr. Jones.
Jones is mental health, Your Honor.
All right, this case 2021 CF 6293 AO. Anybody think he's gonna be available to see me tomorrow, or? All right, well, I'm gonna appoint a public defender to represent Mr. Jones.
We'll waive the appearance, Your Honor.
All right, Mr. Jones is arrested on a warrant, I believe, for attempted sexual battery of a person 18 years or older, false imprisonment, and indecent exposure of sexual organs. The judge already found probable cause for his arrest. We're going to set his bond to count one in the amount of $15,000, count two $5,000, and count three $1,000. Condition of his bond that he had no contact with any victims or witnesses from this case, not return to the scene of the location where this incident happened. He may not possess any weapons or firearms. The weapons or firearms he has need to be returned to law enforcement within 24 hours of his release. Good afternoon, ma'am. Can you tell me your name, please? You gotta keep your face covered.
Marie Lee.
There you go. All right, Ms. Lee, you're here in case 2021 CF 1531 AO on a failure to appear. The judge signed your warrant in this case, set your bond at $0. Your bond's gonna remain at $0. I believe you already had a public defender, correct? You already had a public defender appointed to your case? You have a great day, ma'am.
Okay, thank you.
All right. Good afternoon, ma'am. Can you tell me your name, please?
Haley Letts.
Ms. Letts, you're here in case 2021 CF 8214 AO on charge of possession of Xanax, trafficking in methamphetamine of 14 grams or more, and trespass, structure or conveyance. Did review a charging affidavit in your case. Hold on a second. All right. Yeah, did find probable cause for your arrest as to all three of those charges. One, set your bond in count one in amount of $1,000. Count two, going to stay your bond amount of $5,000. And count three, going to set your bond amount of $100. Condition of your bonds that you do not possess any drugs or alcohol without a valid prescription. You be subject to random drug and alcohol testing. You may not associate yourself with any known drug dealers or drug users. In this case, you need to comply with Florida Statute 903.046 sub 2 sub F. And that whoever does bond you out needs to attest that the funds used to do so did not come from an illicit source, including the ones you're being charged with.
Your Honor?
Were you able to resolve this petty theft?
No, Your Honor. Your Honor, with regard to the trafficking,
Yes.
that's 50,000, not 5.
Sorry, I said 50 or 5? Yeah, I stayed at 50. I reduced the $5,000 possession of Xanax charge to 1,000.
Thank you.
All right. And, all right, so Ms. Les, I'm not going to take any action. Well, actually, in 2021 MM 2904AO, I'm going to revoke that bond. In that case, set a new bond at
Your Honor.
$0.
I don't believe there's a bond in that case. I think she only had a notice to appear.
Let's check. That's correct. So I'm not going to take any action on that case. Ms. Letts, you are very, very young. I mean, I don't know. I mean, unless you just like hanging out with us here at the jail and prison. I mean, see, I don't know what you want to do, but you don't know what you want to do, but you may need to consider making some changes somewhere, somehow, by any means necessary, because it's a short trip down this lane right here, all right? Have a great day.
You too.
All right, good afternoon, sir. Can you tell me your name?
Irvin Royal, sir.
Mr. Roy, here in two matters. The first one being 2021 MO 792AO on charge of open container. You're also here in 2021 CF 8215AO on charge of possession of MDMA or ecstasy. I reviewed both those charging affidavits, did find probable cause for your arrest in both charges. As to your open container case, I believe the city is offering a withhold of adjudication and guilt and court costs to resolve that case. Is that something you want to do today?
Sure.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, sir, you're here in 2021 MO 792AO on charge of open container. That is a second-degree misdemeanor, is punishable by 60 days in the county jail and a $500 fine. Do you understand that? All right, I'm going to take action on these other cases. I want to let you know that before you took this plea, because some people think that just because you resolved the case, I'm not going to take any action on those other cases. I'm just letting you know that right now. But if you want to proceed with your plea, knowing that.
You said you are going to take action, Your Honor?
Yes, sir. And say, have you filed on these other two cases?
I don't believe Mr. Royal wishes to enter a plea on the city case as to those circumstances.
All right, just, they're going to just charge you $10 if you had to file the case. All right.
$59.03, Your Honor, no.
On 5930, you did? So you said yes on 5930?
No.
All right, and then on 4321?
Your Honor, I just said that Mr. Royal didn't wish to enter a plea anymore. But-
No, I was just trying to get some information
Oh,
while we were.
I'm sorry. I thought maybe you misheard and I wanted a factual basis on the charges. I'm sorry.
On 21 CF 4321, yes, Your Honor, he was charged with possession of a controlled substance, possession of drug paraphernalia, and trespass other than structure.
All right, Mr. Royal, you said you want to enter a plea of, what do you want plea would you like to enter to have to resolve the open container case?
Oh, I'm sorry.
But he said he's not.
No.
Oh, I'm sorry. I want to enter a plea.
I'm sorry, I can't hear you.
I want to enter a plea.
All right. As to 2021 MO 592AO, we're going to set your bond amount of $500. Condition the bond should not return to the scene of the location. You may not possess any drugs or alcohol without a valid prescription. In 2021 CF 8215AO, I did find probable cause, set your bond amount of $1,000. Condition the bond, no drugs, no alcohol. No return to the scene of the location, may not associate yourself with known drug dealers or drug users. And you be subject to random drug and alcohol testing in that case. In 2021 CF 5930, and 2021 CF 4321 AO. Court finding probable cause to commit a new law offense while you're out on bond or release in those cases is going to revoke those releases, set new bonds at $0 as to those matters. Going to appoint a public defender to represent you in all your cases. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Eric Slusher.
Mr. Slusher, you're here in case 2021 CF 8209 AO on a charge of grand theft. I did review the charging affidavit in this case, did find probable cause for your arrest. I'm going to stay your bond in the amount of $1,000. Condition of your bond should not return to the scene of the location. You have no contact with any victims or witnesses. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
What was this?
Good afternoon, sir. Can you tell me your name?
Tell me, Sydney.
Mr. Or is your name is Sidney Tillman, or is it Tillman Sidney?
Sydney, tell me.
Is your last name is hold on, Sidney Tillman is your name.
Yes, sir.
All right, there we go. We'll make sure. All right, Mr. Tillman, you're here in cases 2021 CT 4925 AO on charge of no valid driver's license. Viewed that charging affidavit, did find probable cause for your arrest. You're also arrested in case 2021 MM 4797 AO for false information to law enforcement. Reviewed that charging affidavit, did find probable cause for your arrest. You're arrested on a warrant in case 2018 CF 7285 AO on charge of burglary of a dwelling, grand theft of a dwelling of $100 or more, criminal mischief, dealing in stolen property, and receiving money from a pawnbroker by false verification of identification. Judge signed your warrant. In that case, did find probable cause for your arrest. We're going to stay your bond to count one, amount of $5,000. Count two, we're going to set it at $150. Count three, $150. Count four, $1,000, and count five, $150. Condition of your bonds that you're not allowed to return to the scene of the location. You may not have any contact with any victims or witnesses. You may not enter any pawn shops. You may not engage in any secondhand pawn transactions while you're out on release. You may not possess any weapons or firearms. The weapons and firearms you have need to be determined by law enforcement within 24 hours of your release. We're going to appoint a public defender to represent you in all your cases. In 2021 CT 4925 AO, we're going to stay your bond. In that case, I think it's $250. No, it's $500. Condition of bond, no operating a motor vehicle without a valid driver's license. 2021 MM 4797 AO, going to stay your bond in that case, found a probable cause at $500. All right, I got it. All the cases correct. All right, Mr. Tillman, have a great day.
All right, thank you, Your Honor.
Good afternoon, sir. Can you tell me your name?
William Logan Barner.
Mr. Varner, you're here in case 2020 CF 5670 AO on a violation of conditional release. The judge signed a warrant in that case, set your bond at $0. It's going to remain at $0 in that case. In 2021 CF 8213 AO, you're here on a charge of possession of methamphetamine and trespass on a structure or conveyance. I'm going to did find probable cause, going to set your bond in count one, amount of $1,000, count two, $100, condition that you not return to the scene of the location, no contact with any victims or witnesses, no drugs, no alcohol, no associating yourself with any known drug dealers or drug users in that case. I want to appoint a public defender to represent you in all your cases. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
CeeLo White.
Mr. White, you're here in case 2021 CF 81960 on charge of attempted robbery with a firearm and conspiracy to commit robbery with a firearm. I did review the this is a warrant. There's a warrant signed by a judge in this case, finding probable cause for your arrest. Going to state of bond account as set on the warrant, amount of $15,000 in count 1 and $5,000 is count 2. No contact with the victim, no contact with any co-defendants, no contact with any witnesses. May not possess any weapons or firearms. The weapons and firearms you have need to be returned to law enforcement within 24 hours of your release. You may not return to the scene, the location where this incident happened. I'm going to appoint the public defender to represent you in this matter.
Your Honor, would you
Yes, sir.
consider count 2 as a subsidiary,
No, conspiracy is a separate offense.
but as they took place in the same series of events?
If you can be found guilty of, for instance, if it was a completed robbery, and you can be found guilty of conspiracy with robbery with no double jeopardy or any issues in that situation. So it's a completely separate crime.
I understand, Your Honor, it's just his employment status is unemployed and a $20,000 bond.
All right.
You are able to adjust that?
Yep. You can file a motion in front of your division judge, and you can have a full-blown bond hearing where you can accept evidence in that case about that particular issue. You have a great day, sir. All right. Does anybody have anything else before we adjourn for the day?
Yes, Your Honor.
Yes, sir.
May I approach?
Sure. Is it some for the record, or are you something off the record, on the record? What are you going to do?
I just wanted to check with you before